Hi everyone, this is Business Law. Our first lesson, we're going to take a step back and examine what law is and then look at what jurisprudence means. So first we'll define what law is, we'll examine some schools of judicial thought, we'll review the history and development of American law at a very high level, we'll discover the sources of law in the United States, and we'll examine some critical legal thinking frameworks and how they apply to analyzing law in legal cases. So what is law? There are many definitions you'll find. We'll call them a body of rules of action or conduct prescribed by a controlling authority and having binding legal force. So basically, they're rules that a government comes up with that we all have to follow, or else there will be some kind of punishment. What are their purposes? Well, they regulate the conduct of individuals, businesses, and other organizations in society. They forbid individuals and organizations from engaging in certain undesirable activities. Breaking a law can subject a person or organization to legal consequences, whether those be monetary or being thrown into prison or otherwise. And they are intended to protect people and their property from unwanted interference from others. Some additional functions of the law: striving to keep the peace, to shape moral standards, to promote social justice, sometimes to maintain the status quo, facilitating orderly change when change is necessary, facilitating planning, providing a basis for compromise, and maximizing individual freedom. At least we hope, in the United States anyways. Qualities of the law, we're going to be looking at the U.S. system here. The U.S. legal system does strive for fairness. This is a difficult task. We have no delusions that we've actually achieved fairness. It is something we're always trying to reach for. There will be multiple examples of unfair things happening, but in general, we are trying to be fair. We are also flexible, meaning that U.S. law evolves and changes along with the norms of society as technology changes, as the economy grows and expands, commerce in the U.S. and around the world. An example of law flexibility would be the Supreme Court case Brown versus Board of Education. That's where previous to that, Plessy versus Ferguson was the rule in the land being we could have different systems in the United States divided down racial lines. We could have separate facilities, some designated for white people, some designated for black people. The school system was one example of that. Brown versus Board of Education went in and showed that separate facilities were inherently unequal, so it was disadvantaging a group of people. And so we changed the law to say that separate but equal is no longer law in the land, and now we have to have everybody using the same facilities. Okay, we'll look at some schools of jurisprudential thought. First, what is jurisprudence? It's the study of law. We'll study a little bit of law. We'll go over some of the philosophical aspects and, what are the origins of law. So we'll do some of that at the very beginning of the semester, and then we'll dive into the actual business law part. But first, we want to at least give you a little bit of foundation of what law is. So one way people think of law, and just keep in mind that all these schools of thought we'll be talking about, none of them are hammered into stone. I don't think anybody could say that any one of these is the absolute correct answer or the correct school of thought. You might find yourself identifying with one or more rather than others. But the basic idea is here that we're looking at different ways people think about the law and where it came from and what its purpose is. So the first one here is the natural law school. Natural law, basically the idea here is that law comes from something outside of ourselves, maybe something higher than ourselves. You could call that just general nature. You could call that a higher power, like a god. But there are certain rules that are just inherent in ourselves and in nature, or come down from some higher authority that give us this morality and ethics, and that's where our rules should come from. So a lot of people believe this, and that's completely fine. It's very hard to prove one thing or another here. Second, we look at a historical school. And so we're backing off a little bit from natural law, and we're saying that, well, the legal systems that we have are based on an aggregate of social traditions and customs that have developed throughout long periods of time. And we collect all those based on our history, living together as a species or just as a country or as just a small tribe or group of people. Traditions and customs form. And so law is taking our traditions and customs and actually codifying them into the rules that we call law. As norms in society change, those changes will gradually be reflected in the law. We see this happening all the time today. The analytical school says that law is shaped by logic. So the results are reached by applying principles of logic to specific facts of a case. So ideally here, we would take emotion out of the equation. We would look at reason and logic only, apply those to individual cases to reach our decision or our laws. The emphasis here would be on logic of the result rather than how the result is reached. As long as we reached it using logic and reason, we should be okay, according to the analytical school. The sociological school says that law is a means of achieving and advancing certain sociological goals, whether it's to promote equality among genders or races, or whether it's to lift people out of poverty, or whatever the sociological goal is, that would be the purpose of law. Of course, there are elements to this. Probably doesn't explain all of law, but we see these things happening a lot as well. The command school takes a little bit more of maybe a pessimistic view of things, saying that the law is a set of rules developed, communicated, and enforced by the ruling party, and the law changes when the ruling class changes. It's easy to see this in countries that operate more like dictatorships, where the ruling party creates laws based on their individual personalities and what they want. When that ruling class changes, then they can come in and implement a whole new set of laws. A lot of people would argue that that happens, at least to some degree, in the United States as well. We don't have a dictator or a king, but we do have people in high places with lots of power who have lots of influence over how our law is shaped and formed. And as those people change out, then we can see differing priorities and differing laws as the result. The critical legal studies school says that legal rules really are unnecessary. They're only used by the powerful to maintain the status quo, wanting to retain their power, basically. Legal disputes should be solved by applying arbitrary rules based on notions of what is fair. Again, maybe a little bit more of a pessimistic view, but there we go. The Law and Economics School says promoting market efficiency should be the central concern of legal decision making. We see a lot of this nowadays. We're going through the COVID crisis as I'm recording this, and there's a lot of talk about as we've locked down certain parts of the economy and certain businesses aren't able to open yet, to what degree should market efficiency and economic health take priority over individual health and the risk of people getting infected and getting sick and maybe even dying? So these are forces always at play in our life, and it does certainly explain certain aspects of of our law and legal system. Maybe not the entire thing, but you can sort of see that throughout, looking at all these different schools of thought where bits and pieces might be used in different places. So maybe the real answer is that we've taken a little bit of some of each of these schools of thought and applied them to create our legal system. So a very, very brief history of the American legal system. You could teach a whole course on this. Some people create entire careers on this. the history of law, but we're going to just lightly brush over it. The basic idea here was that as we were forming America, we took the English system, which, the colonizers that came over and helped form America into what it is. A lot of them came from the English system. We were an English colony for a long time before we actually declared our independence. So we took a lot of that system that we knew, and we tried to make changes to make it better suit us in this new country. But the English system really does form the foundation on how we developed our legal system. So looking at common law, common law is law that is developed by court decisions. So as judges hear cases, they form opinions and decisions, and then later on when we hear a similar case, either the facts could be very, very similar or somewhat similar, we try to, in the legal system, be consistent. So we make one decision regarding the facts of one case, that becomes a precedent, and then within that circuit, we try to be consistent and follow that precedent. In the English system, they had different types of courts. We have different types of courts too. They'll look different than this English system, though. They had law courts where they applied law strictly and mostly were looking for monetary damages. They had courts of chancery or equity courts when monetary damages just wouldn't do and you're seeking some type of remedy outside of that, and where the law might be applied less strictly and more in a sense of trying to achieve something that's fair or equitable, hence the name. And then finally had merchant courts where we solved commercial disputes based on trade practices and trade usage, basically the way that business is typically done within an industry or among people who have been doing business together for a long period of time. So we adapted that system. We have a little bit different system in the United States, but you can still see bits and pieces of this here, and you can see how they were all adapted for the American legal system. Regarding sources of law in the United States, we'll go over the sources of law at the federal and state levels, and then we'll look at which laws will take precedence over others. So the supreme law of the land is the United States Constitution. Below that, we have treaties that are formed between the federal government and other countries. Below that, we have federal statutes when Congress passes laws. We also have executive orders. Now, executive orders are kind of hard to pin exactly where they fall in the hierarchy here, because there's been a lot of executive orders in this recent administration that a lot of people thought you couldn't do that, but if Congress doesn't hold a president accountable for it, then, I guess there's nothing to rein in his power. So, time will sort of tell how far executive orders can go. But it can be a little cloudy. Below that, we have administrative agencies, so things like the FDA, the FTC. These are agencies established by the government to create rules based on very large and complex issues. They can issue rules, and those rules have legal effect. They are subject to Congress's authority, though. Then looking at the state system, each state has their own constitution. Those constitutions have to be in line with the United States Constitution's principles. Below that, we have state statutes that have to be in line with the state constitution. Judicial decisions I have at the bottom, but the weight of a judicial decision depends entirely on which court is hearing this. Some courts, like the United States Supreme Court, have a tremendous amount of authority. If they make a decision, it applies all across the United States. However, if we hear a case here in district court in Gastonia, then that really only has any weight or authority within our own small jurisdiction here. So judicial decisions can have very broad authority or very narrow authority, depending on the type of case and where it's heard. So, looking at each one of these individually, a constitution is the sort of charter document establishing a country and the basic laws of the land. So the U.S. Constitution is, we call it the supreme law of the land. Every other federal law, every administrative law, every state constitution, every state statute has to be in line with federal constitutional principles. Otherwise, it could be declared unconstitutional, invalid, and unenforceable. The Constitution sets up the entire structure of our federal government. It establishes the three branches that we all know, the legislative branch being Congress, the executive branch being the president and the president's cabinet, and then finally the judicial branch, the system of courts. As we've mentioned before, states also have their own constitutions, which have to be in line with United States constitutional principles. We still do see from time to time when a state constitution will have something in it that would be unconstitutional, out of line with the U.S. Constitution, and that part would either be taken out or just would remain, but everybody would understand it to be unenforceable. Treaties are agreements with foreign countries, so the president, with the advice and consent of 2/3 of the Senate, may enter into treaties with foreign governments. These then become part of the supreme law of the land. The federal government is the only authority that can form a treaty with another country. An individual state can't do it, but the federal government can. Forming trade agreements among countries is something that's commonly done. We have a lot of them. Even with this new administration, some of our trade agreements have recently changed, so these treaties happen. Well, I wouldn't say all the time, but, we see them happen a lot. Federal statutes are laws that are written and passed by Congress. So that would be the U.S. House of Representatives and the U.S. Senate. There are a lot of them, and they are organized into code books. When they're organized into code books, we call them codified law. You can look up these code books either in a legal library by finding the book, or in a more modern sense, you can look them up online. State legislatures also pass laws. Those would be affecting people of that state only. We call our legislature in North Carolina the General Assembly, composed of House and Senate, similar to what the federal government is. And looking at a lower level, even our local towns and cities and counties can have laws. We would call those ordinances at that more local level. If a city passes an ordinance, it only affects people within that city. These are also codified. As I mentioned earlier, a president can issue executive orders. A governor can as well. For instance, a lot of the state governments through this COVID crisis have issued executive orders mandating which businesses can and can't open. There's usually a lot of controversy surrounding things like that. Especially shutting down a business can be quite controversial. So we'll see a lot of legal challenges to state governor executive orders. And then depending on how the election shakes out in November and whether or not President Trump retains power or if it's handed off to somebody else, we could see a differing attitude toward U.S. presidential executive orders as well. Like we mentioned earlier, there are many, many administrative agencies. Think about something like the FDA, the Food and Drug Administration, that has authority to create rules regarding food safety, drug safety. It's pretty relevant today because where there are a lot of rules and it takes a long time and a thorough process to vet. Like if we're going to have a new drug or a new vaccine come onto the market, we have to do a lot of testing, including human testing, to make sure it's safe for people to take. Right now, there have been some of those rules have been relaxed because we're trying to rush a COVID-19 vaccine out into the public. So, the federal government can give authority to the FDA. The FDA can grant special rules to companies who are trying to develop these vaccines, but we're hoping that they're still safe once they get out into the market. And they probably will be. But, the FDA is just one of these administrative agencies. There are a lot of them. When you're dealing with a topic that's really just too broad and comprehensive for individual Congress people to understand, we have these administrative agencies who will specialize in this and do a lot more thorough research and hopefully have a lot more thorough knowledge to be able to pass these rules and then to be able to enforce them later on. Again, judicial decisions. We have a federal court system, and then each state has their own court system as well. As courts issue these decisions, they try to stay consistent internally within their own jurisdiction. This is the doctrine of stare decisis, meaning it translates into let the decision stand, the basic idea becoming once we make a decision, we try to stay consistent with that when we encounter a case with similar facts and circumstances. Now, we don't always follow this precedent. Sometimes decisions are overturned because we think maybe they weren't fair to begin with, and maybe a new rule has to be implemented based on new customs and norms and traditions within the United States. So it's not, the doctrine of stare decisis is not absolute, but more times than not, a court will try to be consistent with itself and the courts higher than it when making decisions. So the priority of law, the U.S. Constitution and treaties will take precedence over all other laws in the United States, whether the federal or state system. Federal statutes take precedence over federal regulations. Valid federal law takes precedence over conflicting state or local law. State law will take precedence over local law, and then right on down the chain. And then again, judicial decisions, it depends on which court is hearing it. Within a state system, the state constitutions rank as the highest state law. State statutes will take precedence over state regulations because states can have their own administrative agencies to regulate things like food and drug safety or employment laws or whatever the case may be. States have their own administrative systems. So state statutes would take precedence over state regulatory law. And then valid state law takes precedence over local laws. We'll mention digital law many times in this class. Basically, every chapter has some part dedicated to digital law. That's just because we're still, and the internet is, 30, 40 years old, something like that now. But we're still getting used to this new technology and trying to figure out how to apply our legal system that is hundreds and thousands of years old, if we go back to English and then Roman law, depending on how far we go back. And now the digital age has happened so fast that it's a struggle for our traditional legal system to keep up. I think we've done an okay job. We've taken some of our old laws and applied them to the new digital age. We've passed some new laws to try to deal with what's going on. So we'll talk about that at least a little bit in every chapter. So looking at critical legal thinking, how to approach legal concepts, how to approach cases. There are a couple methods. If you go to law school, it's still very common for law school professors to use the Socratic method, is where you have a give and take question and answer session between professor and student, where the professor would ask a lot of questions. It would be up to the students to respond, and then you can refine those answers over time, inspiring this critical thinking, making people really think. There's also the IROC method, used to examine a law case. So we would sit down, if we're examining a case, we would look at, well, what is the issue at hand? What is the rule regarding the facts of the case? What kind of rule are we going to apply? We analyze the facts of the case, and then we come to a conclusion. So ideally what we would do is analyze the facts of the case, apply the rule to the issue of the case, and reach our conclusion. So an example case here would be Fisher versus University of Texas at Austin. This did make its way all the way to the Supreme Court of the United States. It had to do with affirmative action in university admissions. Affirmative action is a highly controversial policy, saying that in order to help remedy some of the historical discrimination and differences and disadvantages regarding race, that there might be small areas in the economy where we might give a slight advantage or a slight nod or just a helping hand to a historically disadvantaged group to try to help them pull themselves out of their situation. The facts of the case were, at the time, the top 10% of high school graduating classes in Texas were guaranteed admission to the state's public universities, including UT Austin. The remaining university admission slots were filled based on an applicant's academic index, meaning their SAT scores and high school grades, and also a more holistic view called the Personal Achievement Index, which would include essays they wrote, leadership and work experience, extracurricular activities, community service, and many more factors. Among those many more factors, race was given weight as a factor, the idea being that the university had a compelling interest to try to promote diversity within its student body. Abigail Fisher, who is white, applied for admission to UT Austin in 2008, and she was not accepted. She was not in the top 10% of her high school class. She sues, claiming the consideration of race disadvantaged her and other white students in violation of the Equal Protection Clause of the United States Constitution. Digging into the background a little bit more, what actually happened was that there was an activist group who was highly against affirmative action. They sought out any white student who was rejected, hoping to prove that there had been discrimination. They found Abigail Fisher and tried to use her as a test case to try to show that affirmative action in university admissions is unconstitutional. And on the other side, there were activist groups who were very interested in retaining affirmative action in university admissions, trying to promote that social justice. So your opinion on it can vary depending on your political, moral, ethical beliefs. I won't try to tell you what to think there. You can make up your own minds. So the issue here, is the race-conscious admissions program at the University of Texas lawful under the Equal Protection Clause of the United States Constitution? That Equal Protection Clause in the Constitution says that all laws in the United States should apply to everyone equally. We shouldn't apply laws differently for different people groups. That's the basic idea anyway. There are some exceptions. And the court was considering one of these exceptions. It said the strict scrutiny test should be applied to a rule that treats races differently, meaning that the government should have a compelling interest to impose it, and the rule should not go further than necessary. Translation here meaning that if we're going to have a rule that treats races differently, we need to look very, very carefully at it and see what's the reason for it. And the government would have to prove a very compelling state interest. Here, the compelling state interest would be promoting diversity within university student body. So we would have to show that that's actually an important thing that we should be striving for. Then we also have to show that the rule doesn't go farther than necessary to try to achieve that goal. The ultimate decision of the court was that the university met its burden showing that racial diversity was a compelling state interest. The University of Texas system considered race very narrowly. They called it only a factor of a factor of a factor, meaning that race wasn't the only thing. It was only a very, very small factor. And so the court said, since it showed that racial diversity was a compelling interest, and since the rule was very narrowly applied, they allowed the rule to stand. So as it stands today, affirmative action is an option for universities in admission. but it has to be very narrowly applied. It can't go further than necessary. And that might change over time. We'll have to wait and see. That's it for this first lesson. I hope you all have a great day.